to the, I think it's the 14th Amendment. Here we are. In the 14th Amendment, it says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. Of course, the excuse for having this 14th Amendment was so that the black slaves who had been freed could now have some standing, whereas there was no legitimate way for any slave to become a citizen of the state they were living in. The feds introduced this clause in order to, say, force the states to recognize that these black people who used to be slaves were now citizens of the United States. And if you're a citizen of the United States, you had to be recognized and you got all the benefits, privileges, whatever that you should get. That's the theory. Okay, well, actually this is a Trojan horse here because they wanted to include everybody, okay? They want everybody to be a citizen of the United States. So, but they couldn't change the Constitution to pull in the white folks. So what they did is they changed the educational system. Again, we go back to about 1850 when they created the first mandatory public school, but it wasn't until 1868 that we got the 14th Amendment. And the 14th Amendment defined, you know, there's only one other place where a word is defined in the Constitution, and that's treason. Okay? And now here we have a phrase, citizen of the United States, and it's specifically defined. Not everybody can be a citizen of the United States. Or I should say, not everybody is a citizen of the United States. For example, its requirement is you have to be born or naturalized. Well, if you're born or naturalized, that's easy. Most of us are. But it also says subject to the jurisdiction. Well, what if you're born or naturalized and not subject to the jurisdiction? Well, then you're not a citizen of the United States. You still belong here, but you're not a citizen of the United States. Who are you? Well, I can tell you who I am. I'm one of the people of the United States. Okay? So, are you a 14th Amendment citizen or are you a preamble people? Now, I do not accept the phrase sovereign citizen. Why? Because a sovereign is a master. A citizen is subject to the master. How can you be a master servant? That's why I reject the term. I never use it in my paperwork. In fact, I don't even say sovereign and I don't say citizen. I never use those terms. I stick with constitutional vocabulary. I say I'm a people. Let them challenge it if they dare.
Expertise, agencies, governments defer. And I'm going to talk a bit about how that has worked in the context of broadband network management. So that's one category, right? So there's kind of legitimacy obtained over the course of time because of the good work, the good expertise born from the capacity of the institution to collect information, to engage in consensus-building conversations, but also in the sheer knowledge and wisdom associated with the subject matter that agencies and governments don't have. The second is something that's born from a prior commitment that's evocative of constitutional principles, and that is democratic legitimacy. And that is something that I'm not sure, notwithstanding how wonderful the consensus-building process that self-regulatory organizations are involved in, can make the same claim to. Indeed, you know, there are a whole set of cases in the administrative law setting in which courts make a distinction between the deference that we give because of expertise and the deference we give because an institution is a superior and has more democratic legitimacy. And this is part of the doctrine. And you know, Chevron itself, the case that kind of articulates the view about how when courts defer, talks about the fact that judges, for example, have no constituency. We might say the same about agencies. I mean, we might say the same about non-governmental entities. They don't have the same constituency in the same way that the FCC or even better Congress do. So I'll come back to that in a moment. So this takes me to the discussion about broadband network management. So Danny very helpfully, I think, talked about the ways in which the U.S. government put its imprimatur on what it means to have an internet freedom, right? So we have the CDA, Section 230, which immunizes intermediaries for torts when they're just acting as passive conduits, right? Congress decides to do that, include that. Of course, you have the Supreme Court's decision, ACLU v. Reno, about First Amendment. But it's not just that. It's the a crisper articulation of how this deference worked back then, a deference to self-regulatory organizations, is the NTIA's delegation to ICANN, right? And the assumption that ICANN would be a good administrator of the DNS and IANA function. And better, we can also talk about the FCC's regulatory light touch during this early period. These were the components of what I think people thought of as internet freedom. But to be clear, these were components that were at the early period of this medium. Things have changed, right? We've talked about how it's become contested. Indeed, this is a contested space and no longer the sort of thing that we relegate to the boutique sophistication of engineering solely as engineering. Surely that's an important